About the rigors of class certification? It seems to me that 23B2 classes, and you probably, if you have to, are going to be arguing that they're not so rigorous to meet for injunctive relief for national policies that are uniform.
So the most important thing that hasn't come up in the discussion this morning yet is that they're not available for state litigation. It talks about persons, it talks about appointment of class counsel, it talks about going through the certification process. States, I mean, this court's precedents are really clear about parents patriae lawsuits. States can't represent those individuals in class actions, nor would we try to. They can't represent us, and you don't have classes of states. So the whole framework doesn't apply to state litigation. So I understood how it might come up as an alternative for some other cases you might see in the future, but for the injunction you have in front of you from the states, the whole class device doesn't even work as an alternative. So I don't see how it can be the answer for us.
But why should you care if the class device doesn't work as an alternative if you have bucket one? Like you don't really need the class device. I think what you're saying is, will it be frustrating for states not to have the class device when the individuals have it? But I don't see why that's true if giving you complete relief in bucket one solves your problems.
So I should be very clear, and I'm sorry for the confusion on this. This goes back to my colleague with Justice Gorsuch. When states are seeking the relief, states are seeking it in bucket one and bucket two. As an amicus to the other injunction I recognize courts are looking at, I think bucket three could be available. We aren't seeking relief when it falls into bucket three because, as I was saying earlier, we're not going to be seeking relief for other parties. This court's cases, like Brackeen, make very clear we aren't suing to vindicate the injuries that third parties and our residents are suffering. So when states come before you, the questions that you would ask are the alternative ways of remedying our injury going to be practically or legally workable? And you're going to ask, did Congress authorize it, which gets to the vacator question, which gets to the Hobbs Act question, and so on. And on that first bucket, which I think describes this case well, I had a hard time with some of the colloquies earlier today because I think they were missing some really serious burdens that the states are still going to have to bear in this case if we get something less than a nationwide injunction. I think it's going to hinder the administration of our benefits programs. I think it's going to hinder the participation in our benefits programs. And I think it's going to produce unprecedented chaos on the ground. And I might offer examples of each.
Before you